Good afternoon, everyone, and welcome to the Institute for Health Policy Studies Grand Rounds for March 2026. Today, we're very privileged to have Professor Dorit Reiss from the UC College of the Law, San Francisco, speak to us about vaccine legal policy, federal and state interactions. Professor Reiss is Professor of Law and the James Edgar Harvey Chair of Litigation at UC Law San Francisco. She specializes in vaccine law and policy, including exemption laws and tort liability related to non-vaccination. And we invited her to come because this is a topic that seems to be more controversial than ever in the wake of the appointment of HHS Secretary Kennedy. So Dr. Reiss publishes in law reviews, peer-reviewed journals, and blogs on legal and policy issues related to vaccines, and co-authored a book on vaccines and policy with Professor Tony Yang. She holds a LLB from Hebrew University and a PhD in jurisprudence in social policy from my alma mater, UC Berkeley. And so with that, we'll turn it over to Professor Reiss. As always, we're going to ask you to hold your questions till the end. I think that's usually what we do. But those of you who are in the room can ask live. And those of you who are online, you can put your questions in the Q&A forum as they pop into your head. And we'll alternate between questions from the room and questions from the online audience.
Thank you. Thank you for that wonderful introduction, and thanks for having me. I'm very excited to talk about this. Just to add a point of background, since the issue tends to come up, I've been writing about vaccines and the law since 2013. So, is this better? Thank you. I have a soft voice, so if you don't hear me, let me know. So I've been writing about vaccines in the law since 2013. So I've been following this before the pandemic, but not before some of the tumultuous event of the 1990s and 20s. So that's timing wise. I do have a conflict of interest, which is our family does own stock in GSK. As I found out after I started talking about vaccines, since one of the panels asked me, do you have any conflict of interest? And I asked my husband. I'm going to start by giving everybody a bit of a background about the distribution of roles between the federal and the state government. Some of you know this, some of you won't. I have no way of knowing what your knowledge base is, so I'll give some basics, and I apologize to those that know them already. And then I'll focus most of my talk about current events, and I'm going to tell you that the bottom line I'm going to suggest we take is that we have two problems with the current events in vaccine. One is both the state and federal level, we're having pressures to decrease vaccine uptake, which is directly tied to seeing more outbreak. We're already seeing we've seen over 1,000 cases of measles already in March. We're seeing large whooping cough. We're seeing a lot of influenza, although that's less directly connected to what's going on. Influenza is always tricky. And so one problem is pressures to reduce uptake in vaccine. The other issue I'm going to highlight is a governance problem. We're seeing violation of many norms of good governance by the current HHS. And note, this is not a partisan comment. The norms I'm talking about are norms that have existed across party administrations. The change is current, and it's still a problem. So let's start with the division of roles between the federal and the state government. So generally speaking, this is simplistic. Every time you take a really big symbol and try to boil it down to one image, it's simplistic. But the federal government is generally the one that licenses vaccines initially. There's funding mechanisms both at the federal and state, but I'm going to focus only on the federal ones. So that's why it's there. And in the United States, the federal government took over the role of compensating people harmed by vaccines, and I'll talk about that as well. The state, on the other hand, regulates providers, and providers have a big role in vaccine uptake. People trust the doctors often, although they certainly read things online, but providers have an important role in maintaining vaccine uptake, and the state is the main driver of mandates. I know that there was federal mandates during the pandemic, but by and large, vaccine mandates happen at the state level. Both the state and the federal government have a role in recommending vaccine. I'm going to talk more about the federal recommendation and the state response, but you know that it's always been true that both the federal government and the states have something about that. The federal government has taken up regulating insurance coverage for vaccine in the 1990s in several ways, one of them the Affordable Care Act, and both the state and the federal government engage in monitoring the safety of vaccines. States transmit data if they have it, and the federal government has its own monitoring. Both the state and the federal government have a role in distributing vaccines on the ground and in educating people about it. So that's the general framework, and I'm going to go through it in turn. I'm going to start with the federal government and then move to school mandates because that's another big area of activity. Obviously, I kind of have to pick and choose. There's too much to do in the time, but I'll try to cover the main points. And again, my starting point is that we have a governance problem in the HHS besides the specific policy. And I think this picture typifies that in that this is a picture taken from a May short 53-second video published on X, the platform previously known as Twitter, in which the Secretary of Health and Human Services, Robert F. Kennedy Jr., together with the FDA Commissioner, Dr. Marty Makary, and the NIH Director, Dr. Jay Bhattacharya, announced that they were delighted to tell everybody that they're unrecommending vaccines for COVID for pregnant women and healthy children. Why am I saying that this typifies the problem we're seeing? Because the video was without prior notice. So what generally happens? What generally are we looking for in good governance? We're looking for notice. We're looking for transparency and deliberation. We're looking for an explanation. We're looking for following statutes and the government at least somewhat keeping its word. It doesn't always happen, not perfect, but the video I just mentioned was not notified in advance, was not deliberated. It was a 53-second video that addressed the reason they think that they are going to do away with COVID vaccine for pregnancy, not data in detail, but the reason they think, didn't give an explanation about removing the pregnancy vaccine, and was followed by a very short memo supporting it that had very little data, did not give a thorough explanation. In other words, it's a deviation from the way this would be done. Changing that recommendation is within the Secretary's authority, but the way it was done didn't reflect good governance. The screenshot I have here is another example of the governance problem I mentioned, because what you're seeing is, so there are 4 federal committees that touch on vaccine. This is from the meeting of the Advisory Committee of Childhood Vaccine, one of those committees. It's required to meet 4 times a year. This year, in 2025, they met for 4 hours on December 29. In other words, when most people are on vacation, half an hour for each meeting. That's how they complied with the statutory requirement of 4 meetings. It was clear to everyone that it's not a serious carrying out of the committee's responsibilities. So we have a governance problem, and that's above and beyond the specific issues they're making. Let's talk about FDA. FDA has a role in licensing. FDA also has a role in safety monitoring of vaccine, but I'm going to talk about licensing. And I'm going to start from the end in the sense that I'm often asked these days, can the states license their own vaccines? If FDA stop, for example, puts obstacles that make it impossible to license the annual influenza vaccine and the annual COVID vaccine, can the states fill the gap? I'm not an FDA expert, but I've consulted and looked into this. And the short answer is theoretically, yes, practically, probably not. You can't sell a product in interstate commerce without FDA approval because it's considered misbranded. It's considered an illegal product. California can produce a vaccine inside California, theoretically, if everything that's involved is within California and it's only sold in California. Both those requirements are probably impossible to meet in practical terms. So you'll need at least to bring in one vaccine component, probably from somewhere else. Even, I don't know if it's syringe, etc. You need to have everything in state to be allowed to do that. And you'll need to make sure the vaccine is not sold anywhere else, which is really hard in practice to do. So FDA is kind of our be-all, end-all for licensing and producing vaccines. And it's been acting in ways that make it harder to license vaccine. Unofficially, it means industry stepping out, but FDA has announced more demanding frameworks for vaccine licensing. By itself, that's not a problem, but they announced it via op-eds in medical journal rather than federal documents. Some of these op-eds are behind a paywall. So access is a problem. They've announced it with no deliberation. The way FDA usually set its framework is they publish a draft, they give stakeholder a chance to comment. None of that happened here. So we have frameworks that haven't been discussed, and they tend to be very general in the sense that they don't tell you what the FDA is going to do in practice. That makes it harder for companies, even if they wanted to comply. And I'm not downplaying the need to heavily regulate pharmaceutical companies. FDA has changed, and I'm using the Moderna example as the most recent and critical one, changed trial requirements in ways that are perceived as midstream. For example, they seem to be okay with a trial for an mRNA flu vaccine by Moderna, and then they refuse to take it for review. That's a problem. These trials are expensive. Companies are going to hesitate to try those. So we may end up not having influenza vaccine or new influenza vaccine just because the FDA is putting this obstacle in place. All industry has to do is to stop trying for us not to have new COVID vaccine and new influenza vaccine. And they're certainly discussing that. And why would they not? So one of the things to keep in mind is the change in, you can change your framework. Companies will deal with the framework the FDA set. But rapid changes, undiscussed changes that seems to be aimed to not get these vaccines to market are a deterrent and a practical obstacle. We might not have influenza and COVID vaccines without more transparency and more consistency. Funding. So the federal government has a bigger pocket than even states like California, and it uses it to fund issues related to vaccine. Section 317 is a section in the Public Health Service Act that allows the secretary to give grants. That tells you nothing. So I will mention, and some of you know this, that every state, 8 territories and 6 cities get 317 grants. And in many states, this covers about 40% of their immunization infrastructure. It's a really big deal. Although that hasn't happened yet, the secretary can add conditions to Section 317 grants or reduce them and play with them in a way that will affect vaccine policy. And this is not a theoretical idea because it's been done in other areas. I'll get to that in a moment. The federal government also covers the Vaccine for Children program, which may be more familiar to some of you. That's a federal benefit that is mandatory. It doesn't go through the budget every year. And under this benefit, the federal government has to cover vaccine recommended by the Advisory Committee on Immunization Practices for children who are uninsured, underinsured, Alaska or American or Native American. It's about 53% of the children in the United States are eligible for these. It's a big program. The federal government has indicated very strongly that it's going to use this program as a club. And that's aside from the schedule change that I'll get to in a moment. So the federal government has sent a dear colleague letter to providers threatening that if a state, according to the interpretation of the federal government, has to have religious exemption and doesn't have them, the federal government may cut Vaccine for Children funding for that state. California doesn't have a religious exemption, as you may remember. We removed it in 2015. So this letter is using a program that was designed as a benefit to give vaccine to children who don't have them as a threat to put pressure on states to have religious exemption. It's problematic in several ways. First, it's the federal government announcing that it will interpret state law. Second, it's using a benefit to put pressure. And third, the school mandates are not something the providers that are using the program have any control over or any direct control. So it's an example of a problematic way this is done. Grants. I've already talked about 317, and I'll get back to more mandates. This is referring to NIH grants, research grants for funding vaccine-related issues. And I expect you all know that grants have been cut. mRNA grants and other grants have been cut with very little notice, with letters that are essentially form letters that have very little explanation. Again, going back to governance issue, the federal government has the authority to decide how to spend its money and who to give grants. But it's been doing these cuts with little explanation, apparently little thought, because sometimes they say, oops, we got it wrong, and go back. And they've been losing cases because of that lack of explanation. So I want to mention some other funding battle just to highlight how problematic this is. Early in the administration, the federal government cut $12 billion that were allocated to, although it was allocated to COVID issues, that money was used by states to cover a lot of other public health issues. That money was ending in the summer anyway, but they cut it early. And states sued. There was a coalition of 23 states, red and blue states. This was not a partisan response, and states won, and the money was reinstated. But this is an example of the administration quickly cutting funding with very little explanations that couldn't stand in court. They also, recently the administration announced $600 million cuts to 4 states, California, Illinois, Colorado, and Minnesota. This is separate from a different cutting of daycare funding to 5 states. This is health funding, including for public health infrastructure. This is being challenged in court now. But again, it's an example of we should expect more funding cuts as a way to pressure states, including to push them away from vaccines. And those funding cuts may well, at least that's what we've seen so far, done without notice, with little explanation. And it has a direct impact on states. Even if you win in court, there's a meantime. What do you do in the meantime? For example, Minnesota, in the first round of cuts, fired, I think, about 100 of their health department people because they didn't have the funding. The funding was restored, but you've lost people. There's a time where you are understaffed and so forth. Let's talk about vaccine recommendation. So each state makes its own vaccine recommendation, but the federal government used to have a framework for doing this as well. Since 1964, the Advisory Committee on Immunization Practices, which consists of experts, now they're allowed to have up to 19 people, and they're expected to have expertise in vaccinology, immunology, virology, and a variety of other areas, and a consumer representative. Historically, ACIP would make decisions following a very long, fact-heavy, detailed process. I'm not going to go into the details, but I'm going to point out that it was a long process. How many of you have watched an ACIP committee before 2025? It's kind of a geek's dream and everybody else's nightmare. It's long, it's fact-heavy, it's detailed. I like it because I'm a geek, but most people would probably have their socks bored off. So it was a long meeting. That's no longer true. The meetings are a lot more interesting right now, but not in a good way. In June 2025, Secretary Kennedy fired the existing ACIP via a paywalled op-ed in the Wall Street Journal. The members heard about it when journalists called them to ask them. They did not know of it before. Again, lack of notice, which is a governance problem. You're supposed to do things in a way that follows norms of good governance. He appointed, at this point, there are 15 members, and they have clearly been chosen because every one of them has at some point expressed doubts about the COVID-19 vaccines. Some of them have expertise. So Dr. Cody Messier was an ACIP before. He has extensive expertise in vaccines issues, but most of them don't. Several of them don't have current appointments. Some of them do. One of them has a PhD in nursing. certainly the background, but was chosen because she's a long-standing board member of an anti-vaccine group, the National Vaccine Information Center. Very few of them have scientific credentials related to vaccines. They're also, it's clear that they don't really know what ACIP is about, because a lot of their recommendations are things that aren't ACIP pro, and they clearly didn't understand some of the things they need to do. That's why this quote said, "We are rookies." In December, this committee considered removing the hepatitis B birth dose, and it did, in fact, do that. No subject matters on hepatitis B presented. The people presenting included a climate scientist. In the next slide, you'll see a picture of another one who has a history as an anti-vaccine activist, but is not a scientist in any related matter. And the subject matter experts were on the phone or available for some questions, but did not really get to speak. Commenters called that out, the lack of expertise. One of the people that spoke, one of the liaisons that spoke said, "I wrote the study you're presenting. You misunderstood it, and here's what it actually meant." In other words, the presentation was not based on expertise. Some of the people there are non-experts. So Mark Blaxill, who was one of the presenters, he presented on hepatitis B vaccine safety. He has an MBA, he has a business degree. He's clearly a smart man, but his credentials for this is that he's a father of a child with autism, and he's been arguing that vaccines cause autism since the 2000s. That's not how you become an expert on hepatitis B vaccine safety. Tracy Beth Hogg has a PhD in epidemiology from Denmark, but her background seems to have been in eye medicine, and she worked as a sports medicine since. She's FDA's liaison to the Advisory Committee on Immunization Practices. Again, her expertise is not in vaccines. Now she's the head of the Center for Drug Evaluation and Research, and she doesn't have clinical trial experience. So we're seeing a large role to people whose expertise is in other areas. Again, I'm sure these are smart people, I'm sure they have expertise, but this isn't their area. This has been litigated in court. And the reason I have this is that this lawsuit was brought before the most recent changes and has been amended since. But I want to start with the recent changes. As you may remember, in January 6th, the federal government announced a change to the childhood vaccine schedule without going through ACIP, changing 6 routinely recommended vaccines to not routinely recommended vaccine. Some of them fell under shared clinical decision-making, and some of them became for high-risk categories as well, only. What does this mean in practice? How does that impact us? So there's a number of things that the schedule change meant for us. One is it caused substantial confusion. I'm hearing, and I expect you're hearing more than I am, that people are going to providers and asking them, if these are not routinely recommended, does my child really need this? People are unsure what this means for their child. There's a question about insurance coverage. Right now, the federal government has announced that it's that it's treating these are still covered by private insurance and the Vaccine for Children program. But first, the federal government can change its mind. Under the Affordable Care Act, insurers have to cover routinely recommended vaccine. And in private insurance they haven't yet, can argue that these are not now routinely recommended vaccines, and therefore they don't have to cover them. I'll talk about the state response in a moment. But there are real questions about access if that happens. What about liability? I'm getting questions about what this means for liability for doctors and for vaccines for manufacturers as well. So I teach torts, I teach medical malpractice. On its face, this doesn't really change the situation of doctors in terms of are they liable for malpractice if they give a vaccine and someone's injured? Why? Because the standard for malpractice is, is there a standard of care that supports this? Right now, AAP, FAAP, family, now I'm blanking, Sorry, but several important medical associations are still recommending these vaccines for routine use. So the doctors are covered by standard of care, but they may see more lawsuits because people may say, well, the federal government doesn't recommend this. CDC, which is a really important agency, doesn't recommend this. Maybe this is malpractice. And there's a question. Historically, there are limits on the ability to sue both doctors and manufacturers. You have to go through a federal program. I will talk about this in a little while. That's coming soon. But there's a question, is that still true? So this schedule change has a real impact in several ways on the ground, and it's almost certainly already leading to lower vaccine uptake in the middle of a measles outbreak and pertussis outbreak and bad influenza season. We have seen two lawsuits against this. One is by the American Academy of Pediatrics. The American Academy of Pediatrics has brought other lawsuits against Kennedy. I'm focusing on the one suing, saying that the initial decision to unrecommend COVID vaccine was arbitrary and capricious, and the schedule change was also arbitrary and capricious. That lawsuit has passed the first hurdle in that the federal judge found that the AP has standing to bring that lawsuit. In the United States, you can't bring abstract claims. You have to have a personal stake to be able to bring a lawsuit. We call that standing. So the federal judge found that AAP has that personal stake because they've always educated about vaccine, and this is giving them more work, and the members are at a variety of risks and have burdens. There were hearings on February 13th and today. Yes, today, about this. We don't know what the judge will decide. The hearings were to ask, the plaintiffs are saying the judge should put in place a preliminary injunction, a stay, to stop the coming ACIP meeting. ACIP is scheduled to meet on March 18th to 19th. So they're asking to stop that, and they're asking to put the schedule change on hold. The judge will decide that next week. The hearing today, the plaintiffs feel went well, but with the judge, you shouldn't assume until you see the decision. So we should have a decision in that next week. In addition, 15 states, including California, are also bringing a lawsuit. The AAP lawsuit is in Massachusetts. This lawsuit is in California. And they're making pretty similar claims that this is arbitrary and capricious. This is just started, so we'll see where those lawsuits go. States are also creating alliances and changing their own law. So we have the West Coast Health Alliance, and we have a Northeastern Health Alliance, and we have a more general 15-governor launch, including, by the way, the governor of Guam, one of the territories, because territories are also affected by this. So states are pushing back, and what they're trying to do is pass legislation that does two things. Cut the connection to ACIP on insurance and on pharmacies' power, because pharmacists in many states have powers that are tied to ACIP recommendation, and guarantee insurance and liability protection. So California passed AB 144, which gives liability protection to providers for giving vaccines and disconnects us from ACIP, for good or bad. The problem, of course, is that there is really no smoking section on this plane. We are all kind of in one country and people travel. If we have more disease elsewhere, it's going to come to California. Compensation. So although vaccines are safe, rarely they do anything that works on the body has risks. Rarely there are severe results to vaccine, and the question is, how do you compensate them? In the United States, we are using a no-fault system, which means that people claiming a vaccine injury don't have to show that someone was negligent, don't have to show that there was a broad product defect or any other fault. All they have to show is that the vaccine caused their harm and that there are damages. The United States is one of 25 countries, this is a recent article covering that, relatively recent, it's 2026, and one of 25 countries that does it. And there are, I think, really good reasons to use a no-fault system. No-fault systems are easier on people making these claims. And I think there are two reasons to do this. One is, since vaccines have a public benefit, the rare people who are injured by a vaccine should be fast and generously compensated without having to sue a big company that will push back against it. So it's the right thing to do, give them an easier system. The other reasons that this is the right thing to do is if we want people to trust our vaccine system, we want compensation to be fast and generous. Practically in the United States, another reason to adopt this system was because manufacturers were leaving the market because of the uncertainty of tort liability, and it also protects the vaccine supply. So in the United States, there are two such programs. The Vaccine Injury Compensation Program covers vaccine recommended for children and pregnant people, has a relatively easy standard for causation. It's much easier to win in that program than in the court on causation alone. And it has liability protection, but those are limited. You can go to the court for most claims as soon as you go through the program. For example, Secretary Kennedy has been involved in litigation against Merck over the Gardasil vaccine in the regular courts. So saying that this program prevents people from getting to the court is just untrue. On the other hand, for COVID vaccine, we use a countermeasures injury compensation program. That's a very different kettle of fish. This program is for any emergency countermeasures. So in COVID-19, it was for testing, vaccines, and medicines. It has a really hard standard for causation. You need to show that the product caused you harm with a compelling medical and scientific evidence, a really high bar and really hard to do in a context of an emergency. And it's almost impossible to get to the courts from it. You have to show intentional harm. I think we're shortchanging people with COVID-19 vaccine harm, and we should move them to the routine program. So what's going on with that? Under the new administration, first, we have a bill that's now both in the House and in the Senate, suggesting removing the liability protection from manufacturers and removing maybe the statute of limitation as well. The risk is that if this actually passes, and it hasn't moved yet, it might make manufacturers leave the market. So again, it's a risk to vaccine availability. There are also states' bill on liability. California passed a bill protecting providers. Other states are trying to pass a bill creating liability, saying something along the line of manufacturers that sell vaccine in this state have to agree to waive any liability protection. Those probably won't be valid, but manufacturers will have to sue for that. Secretary Kennedy has said that he's going to reform the system. He thinks it's broken, but he didn't share with us how exactly he's going to reform. So we have to take him on trust, and I'm not sure I'm there. One of the rumors is that he will add autism to the table of injuries somehow. That will require a very lengthy process. I think I have that in the list later, but it's a possibility. And if he does that, it might raise question about the viability of the program because it might exhaust the funds. He mentioned that he might want to move COVID-19 vaccine. The problem there is that, as I said, I think we should move COVID-19 vaccine, but there's two things that need to happen before that, and Congress has to do them. The secretary can't do them. One is, legally, you need to add an excise tax on COVID-19 vaccine to move them to the program. And the second is, right now, the VACP has 8 special masters. I expect there'll be a lot of claim about COVID-19 vaccine. 8 people are barely keeping up with the existing workload. So if we're going to move COVID-19 vaccine, we need to add at least double that. The big question is, remember I mentioned the change of schedule and that a lot of vaccines are now shared clinical decision-making. The question is, are those vaccines still protected from liability? The short answer is there's a legal argument that they're not. Vaccines are under VACP if they're recommended for routine use in children and pregnant women. If it's shared clinical decision-making, the argument will be it's not routine. But there are also pushback against that, which is as long as it's recommended, it's covered, and it's recommended for shared clinical decision-making. And HHS has the same language of routine vaccines is for the Affordable Care Act and insurance coverage. And HHS said, we interpret this to cover shared clinical decision-making. So there's a legal argument both ways. HHS said that they're not going to change the vaccine injury compensation program to remove this vaccine from protection. But they could change their mind. They could say, we think that we have to change it. And lawyers, and some of them have already announced this, may bring cases by people who claim they were injured by vaccines and argue in court, these are not routinely recommended, there's no liability protection, the court should go ahead with the case. I expect we'll see that. In both cases, there's if HHS changes the program, there's going to be a process, a rulemaking process with an opportunity to comment. That's one place where you can participate and make your voice heard. In addition, remember I mentioned that the ACP is meeting on March 18, 19? They now are open for comments. If you want to express your views about the way they should decide, they said they will address COVID-19 vaccine injury, long COVID, and the methodology by which it's made decision. If you want to have input, you can go and comment. Let me spend 5 minutes talking about state vaccine mandate, and then I'll take question. I'm going longer than I intended, but it feels like there's a lot to say. So reminder, the US has school mandates going back to the 19th century. The first mandate was in Massachusetts, the first state mandate, although there was a Boston school mandate. You can all read that, of course, right? You can all read that. Impossible. I have no idea what it said, but it's supposed to be the Boston School Order from 1827. So school mandates in the United States have a long history and have always been contentious, have always been litigated. In the 1960s, studies showed that school mandates are very effective at preventing disease. So that and federal incentives made it so that by 1980, every state had a school that has a law that required some vaccines for school. States varied about which vaccines, varied what the exemptions are, but this is from before California changed its law. The reason I'm showing you this very old map is to highlight that this was not exactly partisan. The two states that at this point didn't have non-medical exemption are those liberal bastions of West Virginia and Mississippi. In other words, this was not, all states had school mandates, and the exemption profile was very state by state and very local politics, not a partisan issue. This is a more detailed image of how this works. You don't worry about this right now. The struggle we're having right now about school mandates is, do they have to have a religious exemption? And this is because of a change in the law. For decades, it was clear that you don't have to have a religious exemption from a vaccine mandate. Every court that looked at it said that. In 2021, the Supreme Court tightened protection of religious freedom in areas that have nothing to do with vaccines. So the question is, does the change in the law mean that you have to have a religious exemption? And right now we have mixed jurisprudence across states on this. As a sidebar, there's also, because the courts tighten protecting religious freedom, it's also harder to deny religious exemption if you have them. So states are facing a situation where if they adopt a religious exemption, it's going to be wide open. Anyone can use it, whether the reasons are religious or not. Right now, we're seeing struggles in a variety of states. In 2023, a judge in Mississippi, a federal district judge, a lower court judge, found that the state has to have a religious exemption. The state did not challenge that, and they now have a religious exemption. They have a lot of religious exemptions right now, and maybe connected, maybe not. Last year, for the first time in decades, a child in Mississippi, a baby in Mississippi died from whooping cough. They haven't seen measles yet. Before the change, they had 99% immunization rates at 5, but it might change. Connecticut, California, and New York all removed the religious exemption in the 2010s. California 2015, and the others later. And they also challenges. So far, in the lower courts, the district court of the circuit court, those challenges lost. California has seen 3 cases saying you have to have a religious exemption in the last 2 years. The district courts, those all lost. One of them is before the 9th Circuit now. That's Royce versus Bonta. If you want to keep an eye, the hearing will be in April. So we should keep an eye. New York had several cases. And recently, the Supreme Court sent back a case, Miller versus McDonald, in which Amish parents sued saying they had religious objection to vaccine. The Supreme Court sent it back for discussion on whether their decision in a case about education, Mahmoud versus Taylor, in which they found that parents have a right to refuse to allow their children to learn curriculum that emphasizes gender identity. They asked the Second Circuit to discuss whether that affects this law. If the Supreme Court was sure either way, they would probably have decided this. So this is a signal that they think there might be something there, but we don't know. So right now there's uncertainty Will the Supreme Court eventually rule that you have to have a religious exemption? We don't know. We really don't. West Virginia is an interesting state. It never had a religious exemption. The legislature tried to pass one every year. But when Governor Morrissey was elected in 2023, he put out an executive order that says schools have to give a religious exemption, even though the legislature rejected it. This was challenged from both directions. The school board challenged it, saying the law doesn't allow religious exemption. Parents required, saying you have to have a religious exemption. Right now, where it is as the Supreme Court is going to hear the case, and right now, schools don't have to give a religious exemption. I'll be really short on this. Like California, New York tightened their oversight of medical exemption, but they did it by agency action, not by a law. California in 2019 created an oversight for medical exemptions after we saw a lot of fake ones. There have been lawsuits, and some of them are very sympathetic about children denied medical exemption. In Doe versus Oceanside, the interesting thing about this case is that this is a kid that had all of her vaccine except the last dose in hepatitis B. Her medical exemption mentions some things that are dubious on their face, but also mentions a previous severe reaction to hepatitis B vaccine, which should be a contraindication. And this girl is now a senior. So she only has 1 year. The judge in this gave a preliminary injunction that said she gets to finish her senior year while the case is being litigated for 1 year, given the unusual circumstances. Anti-vaccine activist followed by writing a letter to all schools saying the judge decided that you have to accept all medical exemption as long as the doctor signed on it. The State Department wrote their own letter saying that's not what the case said and went back to the judge, and the judge says, hey, that's not what I said, and initiated a contempt order against the lawyers. But schools, if you're a school nurse and you're getting the scary letter, the judge said, you're a little scared. So there's a battle there right now about medical exemptions, and we'll see how that goes. States are passing laws to remove their school mandates completely. Idaho tried to do that. It didn't pass for school mandates, although it's passed for workplace. They grandfathered the school mandates. Florida tried, the Surgeon General and the governor announced they're removing the religious exemption, but they couldn't get a law introduced doing that at all. The only law that was introduced this year is a law that would make exemptions easier, and they already have a wide open exemption. Other states are introducing bills to completely remove school mandates. Iowa, Arizona, I just heard Kansas as well. So states are trying to remove school mandates. And at the federal level, so, Representative Stoib proposed a bill that would tie education funding to having a religious exemption. So it would remove federal education funding from states that don't have it, like us. So there's a lot going on. The last thing I'll say is that there's a number of cases by anti-vaccine activists that are trying to put pressure either on the government or on others. So I'll just mention the second one because I really want to leave more time for questions than I've already left, which is a CHD versus AAP, Children's Health Defense. Kennedy's anti-vaccine organization sued the AAP, claiming that they are engaged in racketeering because of their support for vaccines. In normal times, this shouldn't go anywhere, but I'm not sure these are normal times. And I'm a little concerned about where that will go. It doesn't really have a legal basis, but with the right judge, that might not be enough. I'll stop here and I'll take questions, and I apologize for talking longer than I intended. Questions?
We need to use the microphone in the room as well. So we generally start in the room and then we'll do an online one. If you're online, put your questions in the Q&A. Is anyone in the room have a question? I got it.
Hi, Naomi Bardak. Thanks so much. Very interesting talk. I'm a pediatrician, so highly relevant, and I really appreciate all the work that you're doing. I'm kind of curious. It feels like one of the very last slides talking about all these states that are trying to like take away school mandates completely, not just like that there's some exemptions, but trying to take away school mandates. It seems weird from a public health perspective. Like, and also it doesn't even seem like that it would be that popular. Like like, is it real? Are people really this convinced that this is the right way to go politically?
Right on both. So the first thing I'll say is that all of the states that are doing it right now are states that have wide open exemptions. So these are states where someone who doesn't want to vaccinate doesn't have to vaccinate for school, can get an exemption very easily. It is weird, and you're exactly right that this is not particularly popular. So far, those bills haven't made a lot of headway. And even in states, so even in the most Republican states, people support vaccinating for school, although many of them now today would support exemptions. But again, most of these are states that already have exemptions. So I agree that it's strange and it's very unpopular. It's hard to pass in many of these states. These are bills. I don't know if anyone of them will pass. So some of you may or may not be aware that during the pandemic, Montana passed a law making it prohibited discrimination to make distinction on vaccine status. And even they exempted school mandates. So I agree that it's very strange and it's not particularly popular, but there's a lot of pressure. So when Idaho was engaged in their bill, Secretary Kennedy and President Trump called legislators and put pressure on them to support it. So we're going to see federal pressure for this. If you're wondering, what's the effect of removing a school mandate if the state already has a wide open exemption? It's two things. In those states, a school mandate is a nudge. It means that parents who don't want to vaccinate have to submit the exemption. It's a very small burden in most of them, but it's something. So it's a convenience nudge. And the other thing is records. School immunization mandates allow us to keep good records on who's exempt and who's not. And without them, that's going to be an issue. So I agree it's weird and it's not politically popular, but it's happening anyway. So some of the states have people in the legislature who made being anti-vaccine part of their cause and are bringing that, but their colleagues won't necessarily agree. So it's partly homegrown and partly from the federal government.
So we don't have a question online, so we can.
Yeah, I'm curious where this kind of thing is in the law. I have a recollection from my kids' school days where, which was before the religious exemptions were removed for California. And some kid in the school got chickenpox, right? Which some of us of a certain age all got, right? Remember chickenpox parties? But now I'm like, oh, great, shingles, can't wait. Anyway, so somebody got chickenpox and the school I don't know if it was district policy or law or public health law or kind of where this fit in. All the kids who were not vaccinated for chickenpox were sent home to quarantine because they were at risk, which as a parent with with vaccinated kids, honestly, there was some part of me that was like, well, serves you, and then they all complained about how inconvenient it was. And it was like, well, you made a choice. But is that law? Is that public health law? Where does that fit?
At the same time as school mandates were put in place, and I should be careful about the time because I didn't look for the timing on this, but together with school mandates, all states have laws that allow you to keep children who are not vaccinated at home during a pandemic. And you're talking about choice, but notice that these laws say to keep at home children who are unvaccinated, whatever the reason. So, for example, the cancer patient who couldn't get MMR because their immune system is depressed right now would be caught in that. The transplant kid who couldn't get live vaccine, they would also be kept at home during the pandemic. And the rationale is these kids are at high risk. It's partly for their protection, partly to shorten the outbreak. So all states have those. And one of the things we're seeing right now, so it's law, and it's been the law in all states. Together with the pushback against school mandate, we're seeing pushback against this. So Idaho didn't manage to remove the school immunization last round, but they did remove the requirement that children who are unvaccinated be kept home during the incubation period, during the outbreak period. So that's another thing that's currently under attack, the ability of public health to keep those unvaccinated children at home. And that too, in many states, going back to your question, hasn't been that successful in most states. It's also hard to remove because a lot of parents and a lot of politicians say, well, We don't want those children in school during the pandemic. Again, you're emphasizing correctly that a lot of these are unvaccinated by choice, and that's the cost. You decide not to vaccinate. Part of the agreement you make is if there is a real risk of disease, you keep the child. But some of these children that are going to be kept home are children who can't be medically vaccinated, and nobody wants children to lose education without reason. And you can't help. I'm certainly sorry for these kids, but the risk for a transplant kid if they get measles is also really high. So
Yeah, the corollary was one of my daughter's classmates had cancer, and the nurse educators who came from Stanford's pediatric oncology program,
yes,
taught all the kids about what their classmate was about to go through. But then they also sent letters to all the parents asking us to please get flu vaccines to help protect the classmate. And as far as I know, everybody did out of protecting this classmate. So it's just but that obviously had no legal standing. It was just people being
Yes.
good public health citizens. But it's interesting. Yeah, I wondered if that was law or just kind of public health school policy. Interesting.
Okay, first a comment. I love there is no smoking section on this plane because I'm old enough to remember when there were smoking sections on the plane and how easy it was to be stuck in the last row of the non-smoking section. But my question is less that and more, one of the recurring themes in your presentation is at the federal level that there is, under this administration, a way of making announcements that is not consistent with standard practice regarding notice and transparency. And I guess my question is, to what extent can the administration be compelled to follow proper procedure?
So the first thing I'll say, and it sounds like it's not answering your question, but it is going toward that, is that some of the announcements are problematic just from a general government's point of view, but some of them are actually violating laws about notices. So to give, for example, going back to the FDA framework, FDA has published several framework that they treat as general policy in medical journals. Under federal law, general policy has to be published in the Federal Register, not in medical journals, and they don't seem to be doing that. So sometimes they're expressly violating notice and comments requirement in the law. Sometimes it's just bad governance. Whether they can be held accountable for that is going to depend on whether someone has standing. So that's the federal government has kind of played with that in the sense that they've tried to make some of their announcements have more symbolic impact than practical impact. Remember, we can't have abstract lawsuits. You have to have a direct impact on someone. So if the action is just, we think that you shouldn't get Tylenol in pregnancy without any practical action, someone would have to come up and show that this directly affects them, that they were denied access to Tylenol. The manufacturer might have a suit saying, you're reducing the uptake, although even that would be tricky because Tylenol is generic. Acetaminophen is sold generically. There's a question, is there the direct impact? You need a lot of, so without the direct impact, even if there's a blatant violation of the law, there's no need to be grounds for a lawsuit. So the moment it has direct impact, and that was one of the challenges in challenging the schedule change, because the government is saying, well, no impact. We are still covering insurance. We haven't changed the liability situation. So you have to show that this directly affects you.
Thank you. I still do not see any questions online. No, anybody other than Naomi have a question? Okay, no, I think we want to give one bite at.
Absolutely. I'm Vilma Schwartz. I'm the chief of the Division of General Internal Medicine over at San Francisco General. Thanks for a very interesting talk. I tend to work with patients at the other end of the life spectrum. And I'm wondering if there are any other settings besides schools where we have routinely mandated vaccines. We have a variety of people who sort of lose capacity and require more institutional type care, and what the regulations around that are. I haven't
Mhm.
thought about it too much in the past.
So the other two places where we've seen vaccine requirements, so it's actually one place. We've seen it in mostly medical providers in healthcare. So we've seen sometimes it's at a state level. So if a minority of states had at some point put in place regulation requiring medical providers to get, and I'm using medical providers because it's not specific to doctors, and I'm not sure what the other term is. I know that a lot of people don't like the term, but I don't know what else to say. Requiring people in healthcare settings to get influenza vaccine and later COVID, but before COVID vaccine, influenza and a variety of other vaccines, sometimes MMR and hepatitis B. Sometimes restaurants require workers to get hepatitis A. Both of these are regulated under the same framework, which is the Civil Rights Act of 1964. So in the United States, employers can impose workplace vaccine mandates. It's a health and safety rule, and you can regulate the workplace for health and safety. But there are two limits. One is under the Civil Acts of 1964, if a worker has a sincere religious objection to workplace rule, including vaccination, although it was created more for work, the day of rest and head covering and things like that. But this includes vaccination. If a workplace has a sincere objection, a worker has a sincere objection, the workplace has to provide reasonable accommodation unless it's an undue burden. So that's one limit. And I teach this for an hour and I have a minute. So I'm going to stop there, and I'm happy to answer more detailed questions on that. And the other is the American with Disabilities Act requires that if someone has a disability, and under the courts, a contraindication for a vaccine would count for this, they also need to be given accommodation unless it's an undue burden. In both cases, undue burden can be satisfied in some healthcare setting if there's a high risk, but not always.
Naomi, did you have one more question?
It's one-on-one.
Oh, we can't see it.
Okay, that's weird that you can't see it because I see it here. So an anonymous attendee says, given that legal cases are moving so slowly regarding FDA not following its own processes for promulgating rules, are civil cases against the unqualified ACIP committee members by people with standing, such as parents of children who contracted measles or immunocompromised individuals, a viable option?
In theory, so the problem with cases by people. So first thing, you can't bring a direct damages claim, a torts claim against the government on this, because under our law, the government can only be sued when it agrees to. The United States does have a Federal Tort Claim Act, but it exempts government discretionary actions like these recommendations. So it's damages is going to be an issue, but you can bring a claim for an injunction if you show that you're affected. It's probably better to show you don't have access to the vaccine, or as the second part of the question suggested, that you're at high risk for decreased uptake, such as you're an immunocompromised. So it's viable. The cases by the states and AAP are probably more advanced than these cases will be when they start. Unfortunately, litigation is slow. I would point out that legislation and rulemaking are also slow. So there isn't a magic solution here. So I agree that litigation can be too slow. The second one is probably a more viable option than a child that contracted the disease, because that would be more about damages. So it's possible. And I actually hope we'll see more litigation, because I think we haven't seen anywhere near enough, for example, from people who had grant cancels or were dismissed quickly. But it won't be a quick solution. Sorry.
And just thank you, Dorit, for this incredibly informative.
Great question, and thank you.